We're back with our second podcast with Karen Fulton from South African law firm Bowmans. And today we're speaking about the end of employment.
Okay, so first question from us, Karen, is what protections against dismissal employees enjoy in South Africa that an organisation employing people needs to be aware of?
So we do have an unfair dismissal jurisdiction in the Labour Relations Act, in legislation. And we have both a concept of an unfair dismissal and also a concept of an automatically unfair dismissal. The latter it's a bit of a misnomer in the name because it really, once again, it deals with discrimination. An automatically unfair dismissal is a discriminatory dismissal. There are a few other categories, but the main one is that it's discriminatory. And you get a higher damages award in the automatically unfair dismissal versus the damages in an unfair dismissal. The other important thing I think that multinationals ought to be aware of is that in a lot of jurisdictions, the unfair dismissal concept only applies to employees who have been employed for a particular time period or earned below a particular threshold. That is not the case in South Africa. It applies to all employees, no matter how senior, no matter your length of employment.
That's really interesting. And does it apply from day one, even if there's a probationary period in place?
Yes, it does. Although if you are terminating for poor performance, it's got quite a low threshold in terms of the procedure that you're required to follow during the probationary period. There's 4 grounds on which you can terminate fairly in our law: poor performance, misconduct, ill health, or the operational requirements of the business, what you would refer to as a redundancy or a retrenchment. But I think our law is similar in the sense that a dismissal needs to be both substantively fair, which goes to the reason for the dismissal. You must have a sufficiently serious reason to warrant a dismissal. And then also, it must also be procedurally fair. So there's certain procedures that you're required to follow depending on the reason for the termination.
That's good to know. And one thing that we find a lot in the UK is that because unfair dismissal compensation is capped at the lower of the year's salary or £90,000, it's very, very common for employees to then allege either that their termination was for a discriminatory reason or that it was because they were a whistleblower, because those claims are uncapped. Do you have similar sort of issues in South Africa?
We do have similar issues. The one thing that I think is quite different is that we have a reinstatement. You can get reinstated in South Africa, and it's not like an academic award. It really does happen that people get reinstated retrospectively back to the date of their dismissal. And that is the primary remedy in our law. We seldom see it with very senior employees, but you will avoid, the legislation provides that you will avoid a reinstatement order where you have substantive fairness in the dismissal. So where you have a good enough reason for the dismissal, you will avoid a reinstatement order. If your dismissal is substantively fair, so you have a proper reason, but you fall foul of the procedural requirements, you will only damages will be awarded, or only compensation will be awarded. And with the ordinary unfair dismissal, it's up to a maximum of 12 months remuneration. With an automatically unfair dismissal, which would be the discrimination one, it's not uncapped like in the UK. It's a maximum of 24 months remuneration. But obviously the game changer is the reinstatement provision.
Yeah, and reinstatement is in theory an option here, but it almost never happens. Which is why people tend to go for the kind of, we usually see discrimination or whistleblowing being included to kind of maximize the potential compensation.
Yeah, here we often see people asking for reinstatement, even if they don't really want to come back, because it puts significant pressure on an employer to actually settle the matter beyond the limits of compensation that can be awarded.
Yeah, that makes sense. And so do you, presumably in those circumstances, there is both the employee and the employer are presumably both wanted to try and settle and agree an exit, because that's primarily why reinstatement doesn't happen here that much, is because it's difficult for all parties to see how you can rebuild a relationship that's broken down so much that you've ended up in tribunal.
As I say here, particularly with lower level employees, reinstatement is frequently awarded.
Yeah. And aside from the kind of that you obviously mentioned the fair reasons for kind of terminating, can an employer terminate for cause in South Africa? So here we can terminate for gross misconduct, and that's a summary termination. Do you have a similar concept?
We do, but you have to first follow a process. You would have to, the Labour Relations Act sets out that you must, there are a few things that you must do. You must give the employee an opportunity to state a case in response. You must give prior notice of the allegations. The employee is entitled to be represented by a fellow employee. So you can, summary dismissal in our law is you dismiss without notice. And you're entitled to do that, provided, of course, it's gross misconduct, and provided you follow a fair procedure.
That makes sense. And in the UK, so separate to the unfair dismissal protection, an employer needs to comply with the contract of employment in terminating an employee's employment. So this usually requires notice to be given unless you're summarily dismissing. But the contract might give an employer the right to place the employee on garden leave or pay in lieu of notice. Is that something that you have in South Africa?
Yeah, very similar. The Basic Conditions of Employment Act allows the employer to decide whether the employee works the notice period or whether they pay in lieu of notice. Garden leave provisions would have to be in the contract, but it sounds very similar.
And in the UK, there are certain groups of people who have special protection from dismissals, so trade union representatives or women on maternity leave or groups like that. Are there similar concepts in South Africa?
Not really. The two are the two exceptions that you mentioned, actually. So you can terminate a shop steward. You just have to give the union prior notice of proceedings being instituted or being commenced against the shop steward. It's a consult obligation, and consult is inform and listen, not agree, or you really just have to let the trade union know. So you could proceed with discipline and dismiss. It's just the prior notification provision that is legislated. I mean, you wouldn't want to dismiss a woman on maternity leave because of potential allegations of discrimination. But we don't really have a group of employees that enjoy special protection. It's not like there's a list somewhere that sets that out.
Yeah, okay. And I suppose a related point may be, in the UK, we don't commonly have works councils or employee representative bodies, or certainly not formal ones. There are in some businesses. more common in the sort of the rest of Europe, particularly continental Europe, to have sort of works councils or things like that need to approve dismissals, or even labour authorities that need to approve dismissals. Are there any sort of bodies like that in South Africa, sort of internal or external, that are relevant
when there was a whole lot of amendments to the Labour Relations Act around 1970, and there were provisions inserted that that you could create a workplace forum, which is really it's like a works council. But it's so interesting. I think in my 30 years of practicing, I've never heard of a single employer that has a works council. And I think that it's really probably a historical anomaly, because pre a democratic South Africa, one of the places in which people of color could exercise power was in the workplace. And so we still, in many respects, regrettably, have quite a positional adversarial relationship between companies and trade unions. We haven't quite got past that yet. So works councils, no, you don't have to, I'm not aware of any. So, but even if you did have, you wouldn't have to consult a works council before a dismissal. The trade union, it's only the prior notification obligation that I mentioned if you are commencing discipline against a shop steward. Other than that, no, nothing.
Okay, that's helpful. And then just finally on this session, so what practical steps should employers think about when they're trying to resolve termination disputes in South Africa? For example, can you offer a severance package in return for the employee waiving their claims under a settlement agreement?
Look, in South Africa, it's very difficult just to go to an employee and say, I'm sorry, we're at the end of the road, we'll pay you some money, you must sign an agreement and go, because that in our law is an unfair dismissal. So it's quite a balancing act between, because obviously, particularly in relation to senior employees, exits are usually done by agreement. But employers need to make sure that they cover themselves legally, and also that they don't compromise their bargaining position. And so we often recommend a two-pronged approach where the law, where an employer commences a process under the law as required by the law, and then sort of simultaneously unrelated people that are not involved in that process, unrelated people, talk to the employee about the possibility of an agreed exit.
Perfect. Well, thank you for that. That's been really interesting. And so that concludes our podcast covering the end of employment, and we'll be back in the next podcast covering other key employment law topics in South Africa.